to your favourite show, The Legal Show, live on C Channel right now. I'm your presenter Hamrad Singh, also known as Flexing, and today we're very blessed to have Ash back on the show today as well.
Thank you.
How are we doing, Ash?
I'm good, thank you. How are you?
I'm very well. I'm very well.
And thanks for inviting me back on the show.
No, it's the least that we can do. It's the
you.
least that we can do. So how's your day been so far?
Oh, it's been very, very busy. So I've had back in work in the morning. I had a networking lunch in Solihull.
Amazing.
So part of our job now as being lawyers is to go out and network. So one of the three biggest challenges facing lawyers today is going out and winning new business, retaining existing clients and compliance as well. So it's not just about sitting behind a computer and doing the work. We have to go out and network, build relationships
and meet new people,
meet other professionals as well. So I'm a member of a ladies group as well. So we had a Christmas lunch today.
Oh, lovely.
And then
it's a bit early for Christmas lunch, don't you think?
A bit early, but there's loads of events starting now. So we're only 6 weeks away from Christmas now.
That's true.
So we're all getting into the Christmas spirit. So lots of quizzes, lots of dinners as well, Christmas parties as well. Is that just that time of year? But we still have to go out, network, and build up, bring in business.
That's fantastic.
Yeah.
So would you say networking these days has become a lot more easier than days before?
I think a lot of lawyers today, I think there's a lot more pressure on lawyers to go out and network, as well as doing the fee earning. Doing that, the priority is to do the fee earning. But when I first started out as a lawyer, and when I started training as well, we never used to have to do networking. So, but we now are in a digital age. We've got technology as well. Right. You now, as a lawyer, have to be more business orientated as well, be tech savvy as well, do a lot on social media as well, raising your personal and professional profile, going out and building relationships with people as well, and try and win new business.
Wow, that's fantastic.
So yeah.
So you would say that in these days, using the advantage of technology, is very important to make sure that you use the benefits of it and actually network with more people and overall gain more business as well. I feel that
as a law firm, law firms have to evolve their business strategies to adapt to we're now in a more client-driven market. We have to meet the client's needs as well, and understand what their objectives as well. So we have to. I think there's at least about 500 to 600 law firms opening up every year.
Okay.
So there's a lot more competition. There's more increased competition. The market's quite saturated as well. And I think to stay ahead of the competition, you have to evolve. And you have to adapt your business strategy, and you have to go out and get work and be more business orientated.
And find a competitive advantage as well.
Yeah,
overall.
Definitely.
That's fantastic.
Definitely.
So Ash, we're on the show here today to discuss a new topic, as always in every show.
Yeah.
So the topic for today is about divorce.
Yes.
And so it's a topic that people do want to know a lot more about.
Yeah.
So hence we're doing it today. Yeah. So in general, what would you say a divorce is, and how does one come about?
Yeah, so I'm a family lawyer, so I specialise in divorce.
Fantastic.
So the divorce rates have actually fallen. They've actually fallen. More and more people are living together. But a divorce is when a wife or a husband comes to me and they say that their relationship has broken down. They maybe have broken down because one party has committed an adultery, or there's been a lack of communication. It's because of one party's behaviour, or they both have gone they've both gone their separate ways, and they no longer have anything in common, and they want to end their marriage.
Oh.
So and unfortunately that happens. And I'm there to help them and guide them through the divorce process as well. So, but in order to legally go end your marriage, you have to be legally married for 1 year before you can go ahead with a divorce.
Okay, interesting.
Under English law.
Okay, so of course in the ideal world, you wouldn't want to have a divorce, but unfortunately we live in a world where people do have divorces, and they do have to go through these kind of stages.
Yeah.
And coming through, talking about divorce, if we were to say, talking about the procedures and how long it takes, and for someone to actually apply for a divorce in a legal standing, how does that actually happen?
So what happens is, if, for example, a wife comes to me and she says to me her marriage is broken down, under English law, your marriage has to irretrievably have broken down, and there has to be no prospect of reconciliation. So first, you would explore with the client first whether they do want, relationship counselling. If that's not an option, and they both want to go ahead with the divorce, then there's one of 5 facts that they can rely on.
Okay.
And that's usually the first, adultery. A second could be behaviour. And when we say behaviour, it's unreasonable behaviour. So the test is subjective.
All right.
So it could simply mean, it doesn't have to be an extreme form of behaviour. It could be like a lack of communication between the parties, or one party was always engaged with a hobby, like maybe golf, or tennis. Or, for example, the parties just simply they've moved away. They've no longer got any common interest between them. And then you've got the 2-year separation if they've been separated for 2 years. But if they want to do that, then the other party has to consent to that 2-year separation, or the 5-year separation ground.
Okay.
So you have to rely on one of those 5 facts, and then you would get the petition, draft the petition,
yes.
and then you would send it to the other side before you issue it at court,
Okay.
and then to minimise conflict and distress. And then if the other side, you can agree everything, then you would issue the petition at court. A divorce usually is straightforward. It's a paper application to a court. It usually takes about 3 to 4 months.
3 to 4 months.
If it's straightforward,
If it's straightforward.
it's undefended, and the
Okay.
other party signs the paperwork and submits it to the court on time.
Okay. So on a good day, 3 to 4 months.
On 3 to 4 months roughly it should
Okay.
take. But and our divorce system now is centralised as well. So we issue there's centralised divorce units to minimise the delay as well with divorce. But yes, if both parties are amicable and they're agreeable, and they can both agree on what ground that the other party wants to rely on, then usually it's a straightforward procedure.
All right. Okay.
3 to 4 months.
3 to 4 months.
Yes.
But it can potentially take longer as well, depending.
If one party decides to cross-petition or defend the petition, yes, it could take longer. It would increase the cost for the other party as well. But we have to follow the guidance given in the family law protocol. So as a legal practitioner, I have to follow the guidance that the protocol says. And the protocol usually says that if, for example, I have a wife who wants to petition on her husband's behaviour, good practice is for the husband solicitors just to simply say, look, we will accept the allegations made by the wife.
Okay.
However, we reserve the right to defend them, but we will allow the petition to proceed undefended, just to allow the petition. Because unfortunately, under the current law, under the current law, one party has to rely on fault.
All right.
One party in order to go ahead with the divorce, and that's what the current law is.
All right.
But that law might now change.
Okay.
So we have a bill that was introduced, the Divorce, Dissolution and Separation Bill.
All right.
And then that fell away when Boris suspended Parliament in September. That bill was killed off.
Oh, yes.
But the good news is it was reintroduced in the Queen's speech on the 14th of October. So it's now back on the agenda. And the proposed new reform, because the current law is very outdated, it needs to be modernised. So the new divorce law, under the new bill, the proposed reform is that it will remove the right to defend a petition. So you won't be able to defend the petition. You can both issue a joint application, and it will also remove, you don't have to rely on fault. So there's quite a big change in the proposed divorce law, and hopefully that will come through. I don't know when, but it's back on the agenda.
Fantastic. So, of course, in the UK, this is a very common saying where people say, God saved the Queen.
Yes.
So, would you say in this case, the Queen has saved, the UK?
Yeah, well, it's back on the agenda, and it was announced in the Queen's speech, and it's much need. The resolution, which is a family law organisation, which we follow the codes of practice as a family lawyer, and they've been lobbying and pressurising the government to change the law, and hopefully that change will come soon.
Okay.
But that's the good year, because we now in a society where from 50 years ago, the family structure has changed. It's evolved. We no longer have a nuclear family. We have multiple families of stepchildren, remarriages as well. So, and more and more people living together. So, and our laws are very archaic. They're very, they need to be modernised.
They need to be modernised, especially in a world where everything's advancing a lot more faster as well.
Yes.
So it only makes sense that the laws, modernise as well.
Yes.
That's a very good point. That's a very good point.
Yeah.
And to continue on as well, does it matter when it comes to like a divorce? Does it matter who actually issues the divorce?
So really, it doesn't really matter who issues the divorce petition.
Okay.
Yes, if one party does issue the petition, like the wife or the husband, it does give them more control, but it has no impact upon the financial matters.
Okay.
So what would normally happen is you would issue, if both parties agree they want a divorce, then one party has to issue the divorce petition relying on one of the 5 faults, either the adultery, behaviour, 2-year separation, 5-year separation or desertion. The most common grounds are adultery or behaviour. And
are those the ones that you tend to commonly?
Those are what I find common. Those are the most common facts that people rely on.
Okay.
And then yes, it has no, whoever issues it, but the petition, it doesn't really have an impact. It does not have an impact upon it gives one party a bit more control. But really, you're just simply saying to the court, look, one party might feel strongly that the other party is, it was because of their behaviour, the marriage is broken down, so they want to issue the petition. But
okay.
No, it doesn't. Overall, it doesn't really have an impact upon the financial matters.
Okay, fantastic. So yeah, I was about to talk about that as well. About the financial aspect.
Yeah.
So overall, it doesn't make any impact on the finances.
Yeah. So whoever issues the petition, it does. Overall, it doesn't have no impact upon the financial matters. It just gives one party probably a bit more control of the divorce proceedings.
Oh wow. Okay, so there have been some questions raised on the online platform as well.
Yeah.
So I'm going to quickly go read those on my mobile device as well.
Yeah.
So it says that, so one person has asked, just generally speaking, what will a divorce cost in general?
We offer a fixed fee for a divorce. So it depends who you're acting for, if you act for the petitioner or for the respondent. So if the wife is going to petition for the divorce, she's called the petitioner. And if the husband then is the respondent in the divorce proceedings. If you act for the petitioner, then basically you have to do most of the paperwork for the divorce. So you have to issue the petition, you have to draft the petition, you have to send it to the other party, you have to apply, go through the process, apply for the decree nisi, apply for the decree absolute. So yes, it could cost maybe up to £1,400.
That's a lot for a baby, to be honest.
But then part of that you also have to pay for the court fee to issue the petition, which is £550. So we offer a fixed fee for the divorce.
Fantastic.
We offer a fixed fee for the divorce, but that includes the court fee of £550, and it also includes the VAT as well.
So it's all inclusive.
So it's it's a fix for undefended, straightforward divorce.
That's brilliant.
Yeah.
That's amazing. Okay, fantastic. So I'm going to continue reading some more questions. So I hope the person who's asked those questions, I hope those have been answered very well. So thank you for sending in your questions. So going on to the next question now. Just trying to see some nice ones. Okay, so we've got a nice question here. So is there an alternative to taking a trial?
To?
Taking a trial.
A trial?
A trial, yeah.
So in what context?
So that's all the question. That's what the question said. So we can create a context. So the person who's asked the question, if you want to send us another message across, giving a bit of context, that would be nice.
Yeah.
But the question generally was, is there an alternative to going to a trial?
Well, for example, you could have like if you with financial matters. So when you have a divorce, you have to sort out your financial matters, okay? And then sometimes if people cannot agree their finances voluntarily, sometimes you have to advise one of the parties to make a financial application to the court, so the court can adjudicate on the parties' financial matters. But we always encourage our clients, if we issue a financial application to the court, that's a last resort, because most parties want to avoid court litigation because it costs money. It increases the party's costs. And when you issue a financial application to the court, you go through a process. So you have a first hearing, you have a second hearing, and then you would have a trial. But there are alternative routes now. There's arbitration, where you can private arbitrations. You can have private financial hearings as well, because the court process is, for most people, it can be quite stressful as well. It's costly as well. Yes, there are alternatives, but sometimes you do have to end up going to court, and sometimes you could end up having a trial as well if you cannot, throughout the court process, if you cannot, you issue a timetable, the court will issue a timetable, but if you can still not negotiate and reach an agreement in the court process, then there will be a situation where you do end up at a final hearing, a trial.
Yes.
Okay, where the judge will then make a final decision. But then there are alternative options. There's like you can attend arbitration before a judge. An arbitrator would be an experienced judge where you sit in with your barristers and with your legal representatives, and you try and reach an agreement. And an arbitration decision is binding as well. So that's an alternative to having a trial.
Okay.
But most people, they don't want to. Going to trial would be the last resort. But in some situations that does happen. But what we do is if we end up making a financial application, so if the wife and the husband cannot sort out their finances and divide up their assets fairly and reach an agreement outside of a court, yes, you make a financial application to the court, but then hopefully it will put pressure on the other party to try and negotiate and to try and reach an agreement against in the court proceedings. But the court proceedings, it's a formal process. It's like a 3-tier process.
Okay.
And you have to go through the process, and the trial is the last resort.
All right. Okay. So talking about dividing assets, we just had the question from a lady who wants to keep her name anonymously because you can understand. So she says, hi, I'm looking to apply for a divorce petition.
Yes.
But she's afraid to do that because she's worrying about how will her property be divided.
Okay. Well, so what she needs to do is in the petition. So the divorce has no impact upon the financial matters. So by issuing a divorce petition, what she's doing is she's issuing in relation to the divorce. She's saying that she's saying to the court, I'm presenting a petition because my marriage has come to an end. The finances about her property will be dealt with within the divorce proceedings.
All right.
But then it's really important that in her divorce petition, she ticks all the boxes, where there's a bit in the end of the petition, in the prayer to the petition, that it says about making financial claims, and it's standard to tick all those boxes. So even though you might not want to make an application to the court, you still tick those boxes to protect yourself, that if you can't reach an agreement and you have to go to court and you have to issue an application, you're sure you've ticked all those boxes.
Okay.
But the issue about her and her property, and that she needs to seek advice from a solicitor as to what options she has with regard to sorting out her finances and what type of orders that the court can make. So the court can make property adjustment orders. So if you have a property, the court can say that that property should be sold. It could be transferred into the name of the other party, or you pay if the other you can buy out the other party's interest and pay a lump sum to the other party to buy out their interest, or you sell the property and you divide the proceeds between you.
Okay.
And how you divide it depends on what each party needs.
Fantastic, fantastic.
But the starting point is 50-50.
50-50.
And if one party needs more, usually the mother with young children, she will get more if she needs more.
Oh, that's interesting. So, ladies and gentlemen, there we go. So we've been going through a lot of your questions right now. Thank you for sending them in so far, and we hope that we have answered them quite well for you guys. I mean, we've got a few more questions coming down as well. I mean, my phone is literally being spammed right now full of questions. But don't worry, guys. We're gonna try get to all your questions as quick as possible. We're nearing to the end as well. So we got one more person over here. Okay, so we've got a gentleman right now. Obviously, we're not going to mention his name, but he says, hello, my name is He's wondering who will get custody of his child if he goes for a divorce proceeding.
Okay, so if there's issue at child arrangements, so we're talking about child arrangements contact, so it's called trial. So if they cannot agree the child arrangements between them voluntarily outside of court, then and there's a dispute of who the child should live with and how much time the child should spend with the other party, then they would have to make an application to the court. Either the mother or the father can make an application to the court for the court to determine who the child should live with and how much time the child should spend time with the other party.
And just out of curiosity, is the person who probably sends the application towards the legal proceeding, does that give them the advantage of having...
Not necessarily.
No.
At the end of the day, the court, what the court has to take into consideration is that the child's welfare is of the paramount consideration.
Okay.
And the court has something called the welfare checklist under the Children Act. They have to consider all the statutory criteria of who can meet the emotional and physical needs of the child. They have to consider the child's educational, physical, emotional well-being, whether that child is at risk of harm. When I say harm, it's just not just physical harm, it could be psychological harm as well. Usually the courts like to maintain the status quo. So if the child's been living with the mother for some time and the child is settled, is in a routine, is doing well at school, then the court would prefer to keep that, maintain that, and not uproot the child or cause any upheaval, which might be detrimental to the child and not in the child's best interest. But the courts are moving towards shared care arrangements. So you could
what's that all about?
So a shared care arrangement doesn't necessarily mean 50-50.
Okay.
It could mean, for example, that the child lives like with the mum, but in week 1, the child has midweek overnight contact with the father.
Okay.
And then the parents alternate the weekends.
All right.
So then week 1, the father has midweek overnight contact, mother has a weekend, and then the week 2, the father has a weekend contact. Week 3 is the same as week 1, and week 4 is the same as week 2. That could be like a shared care arrangement.
Okay.
Or you could have an equal shared care arrangement as well. When you look at child arrangements, you have to look at, you have to think about flexibility.
Yeah.
You have to think about what's practical for the family, what fits into the working,
The routine.
everyone has different lifestyles, different working patterns. So you're going to think of an arrangement which fits with your work life, with the children, what's in the best interest of the children.
That's
what you
correct,
don't want is the children being toing and froing between one household and another.
Yeah.
So you need,
especially when they have stuff like school going on, or after school clubs, or like societies that they join.
One, could have block contact as well. So, you don't want them just toing and froing between one household and another.
Yeah.
There has to be a smooth transition for the children from one household to the other household. And the whole point of shared parenting is that both parties can meet the emotional and physical needs of the children and their educational needs.
Okay. So it's nice to hear that there is some kind of, legal standpoint where you can actually support the child as well.
Yeah.
But I still find it quite shocking that, although it's a dispute between the parents itself, that the child is kind of thrown in the middle of the whole fire.
And the courts take a dim view of that. So where one parent uses the children or the child as a pawn, because of the acrimony and bitterness between the parties, the court will take a dim view of that.
Okay.
And you have cases of parental alienation where one party alienates the child against the other parent, and that does cause psychological harm to the child. And then that does impact upon the child, and also what parents are under the contact is the right of the child. So both parents should be encouraging and facilitating and promoting contact and allowing that child to have contact with both parents, so that to ensure that the child has a relationship with both parents.
Okay. So, ladies and gentlemen, thank you for tuning into the legal show this today. So, Ash, thank you for coming in and giving your expert advice.
Thank you.
Fantastic what you're giving in today.
Thank you.
And today's topic was about divorce, ladies and gentlemen. Of course, we don't recommend going through divorce procedures. Ideally, in an ideal world, it's easy to say, but it's hard to do as well. But Satsang Ji, there is legal help out there if you do need help. And definitely, Satsang Ji, thank you for tuning in to the legal show. Ash, once again, thank you for joining on the show. Maybe we'll wonder what topics on for next week. But until then, Satsang Ji, stay tuned, keep yourself healthy, and we will catch you guys in the next episode. Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh.